Welcome to this explainer. Today, we're diving into a truly baffling logistical paradox. Since early 2025, the US government has been flying Mexican nationals thousands of miles away to Central America. Now, think about that for a second. Why fly citizens of a neighboring country entirely over their homeland, at a massive expense to taxpayers, I might add, just to drop them in places like Guatemala and Honduras? Well, let's unpack the fascinating and highly controversial legal gray zone that makes this entire operation possible.
Here is our quick roadmap for today. We'll start with the deportation paradox itself, then look at how the government is stretching INA Section 241B. After that, we'll cover executive discretion in action, the ongoing judicial ping-pong playing out in the courts, the human rights risks involving due process and torture, and finally, the ultimate strategy driving all of this. Remove now, litigate later.
All right, kicking things right off with Section 1, the deportation paradox. On its face, you have to admit, this practice seems completely irrational, logistically. Why would the Department of Homeland Security fly Mexican citizens to Guatemala and Honduras, totally bypassing Mexican airspace, when the Mexican government publicly accepts the return of all its nationals? Mexico explicitly says, hey, we have no agreement authorizing these third-country transfers. So what is the real strategic motive here? Well, the answer really comes down to a harsh strategic calculus. Sure, returning someone directly to a Mexican border city is fast and it's cheap, but it carries a very low deterrent value. I mean, they can literally just try crossing again a few hours later. Conversely, these third-country flights use expensive military aircraft and carry super high legal exposure. But the administration deliberately accepts these massive logistical costs to achieve an exponentially higher deterrent. Dropping someone thousands of miles away transforms a routine deportation from a temporary inconvenience into a virtually insurmountable barrier. That brings us right to Section 2, stretching in a Section 241B. So, to actually understand the legal justification for this, we have to look closely at the Immigration and Nationality Act. Under Section 241B, the government has to follow a very strict three-step hierarchy. Step 1, the individual designates a preferred country. If that doesn't work out, we move to Step 2. They are sent to their country of citizenship, which in this case is Mexico. Step 3 allows removal to another accepting country, but, and this is a big but, only if Step 2 is deemed impractical, inadvisable, or impossible. And right there is where we find a massive legal loophole. How exactly does the administration stretch the definition of the word impracticable to just completely skip Step 2 and bypass Mexico entirely? Remember, Mexico's foreign ministry explicitly stated they will absolutely accept their citizens. Despite this glaring factual contradiction, the U.S. government claims broad executive discretion to make that impracticable determination anyway, completely regardless of Mexico's stated willingness. Which perfectly tees up Section 3, executive discretion in action. To support this massive operational latitude, the administration leans heavily on a 2005 Supreme Court precedent called JAMA v. ICE. This ruling established that the U.S. government doesn't actually need the explicit advance consent of a destination country to designate it for removal. Now, even though this specific case was decided under a totally different factual context back in the day, the administration is using it today to assert the authority to send Mexican nationals to places like Honduras and Guatemala. And they are often leveraging asymmetrical power dynamics, things like foreign aid, to basically ensure those fragile nations accept the incoming flights. Moving on to Section 4, the judicial ping-pong. As you can probably guess, stretching a statute this aggressively has triggered some really intense, chaotic battles in the federal courts. Just look at this timeline. In early 2025, a district court issued an injunction to stop the flights entirely. But then by June, the Supreme Court granted a stay, allowing those removals to continue. Then, fast forward to February 2026, a district court explicitly declared the policy unlawful all over again. And just a month later, an appeals court issued another administrative stay, letting the flights resume. It's a relentless judicial ping-pong match. Lower courts block it, higher courts pause the block, and the flights just keep taking off. While the legal system rallies back and forth, we hit Section 5, due process and torture. Because while the courts bounce this issue around, massive human rights concerns are slipping right through the cracks. When lower courts rule this practice unlawful, they consistently flag severe due process issues. Deportees are allegedly given absolutely no meaningful notice of their destination country until they are essentially walking onto the tarmac to board the plane. On top of that, they're given virtually no opportunity to raise a fear of persecution or torture. The end result? Vulnerable individuals are just being stranded in foreign nations that already have incredibly fragile, overwhelmed asylum systems. And this brings us to a major international legal threshold. Without proper screening, this controversial practice seriously risks violating the Convention Against Torture, or the CAT.
The CAT explicitly prohibits what's called refoulement, which is the return or transfer of individuals to a state where they face a real risk of torture. By dropping migrants into completely unprepared nations, the risk of chain refoulement becomes very, very real. This instantly elevates the whole situation from a domestic statutory dispute into a massive international human rights issue.
And that brings us to our final part, Section 6, Remove Now, Litigate Later. Ultimately, this whole thing comes down to a structural asymmetry. On one side, you have this sheer speed of physical deportation flights. That is a process that takes a matter of hours. On the other side, you have the notoriously sluggish timeline of the federal appellate courts, which, let's be honest, can take months or even years to issue a final, binding decision. So by the time a judge can definitively rule on whether a transfer under the INA is actually legal, hundreds, if not thousands, of removals have already happened. And that creates an irreversibility that entirely outpaces the justice system itself. It is a highly calculated strategy. Remove now, litigate later. It's a pretty sobering demonstration of how physical enforcement maneuvers and sheer operational tempo can be utilized to effectively bypass judicial review. The administration is essentially combining legal loopholes and logistical speed to create facts on the ground that the legal system simply cannot unwind. So as this legal gray zone continues to be heavily exploited, it leaves us with a critical, lingering question. Will the courts eventually catch up to the planes? Or has a new, permanent loophole in immigration enforcement just been forced open for good? This has been Eyes on Ice Investigates. Find more research and articles at www.eyesonice.net.